Hello, I'm Katrina Crooks and I'm a litigation and dispute resolution partner at Shelston IP. Today, I'm here to talk to you about how both the Australian Patent Office and the Australian courts are taking a strict approach to the patenting of business methods, even where the method is implemented by computer software. Patents give their owner a monopoly over the technology covered by the patent for 20 years. Not only is this an important way of restricting others from taking advantage of your ideas, a patent is also a valuable asset when it comes to potential sale of a business or seeking capital investment. For those in the areas of business or financial systems, the increasing ambivalence towards patents for these fields of endeavour may mean they are unable to take advantage of these benefits. Although computer software attracts copyright, the protection is more limited in a number of respects. But the outlook is not altogether bleak. The recent decisions have shown that the precise terms of a patent application can really count in getting it across the line. It's therefore critical to seek professional, specialised advice at a very early stage to have the best possible chance of obtaining patent protection. Meanwhile, the position in different countries can vary quite significantly. It may be possible to get patent protection in one country, but not another. A well thought out strategy for patent protection is essential to make the most of valuable ideas. In 1959, Australia's High Court delivered a landmark decision in a matter brought by the National Research Development Corporation against the Commissioner of Patents. That decision established that to be patentable, an invention had to result in an artificially created state of affairs. Subsequent cases added the requirement that an artificially created state of affairs must involve a physical effect, in the sense of a concrete effect or transformation. Following an important decision in 2006 in the Grant case, it seemed clear that pure business methods involving only artificial constructs were not eligible for patent protection. However, if the invention was implemented by software, this would satisfy the physical effect requirement. The tide began to turn in 2010 when the Australian Patents Office rejected a computer software patent on the basis that it used the computer in an incidental way. It suggested that the computer must be central to the purpose or operation of the claimed process. In other words, if a method could be performed manually, however onerous the task, then the computer is incidental and the method not patentable. A string of subsequent decisions made it extremely challenging to obtain patent protection for inventions where the technology was perceived as being business-related. The APO's approach has been met with criticism, particularly given that it was not based on any principle espoused by the Australian courts. In 2013, two important decisions concerning computer-implemented business methods were given in the Australian Federal Court. Shelston IP was involved in one of these, which is one of the most important Australian decisions to affect the patentability of computer-implemented business methods. Shelston IP acted for research affiliates, which applied for a patent for a computer-implemented method for generating an index. For example, an index of shares upon which an investment strategy could be devised or benchmarked. The Australian Patent Office rejected our client's application on the basis that it failed to show that the computer aspect of the invention was central to the working of it. Our client appealed to the Federal Court and the Patent Office's decision was upheld, although on somewhat different grounds. It found that the index was simply information and that while the index could be stored in the computer's memory, that could be said of any data generated by a computer. The court also suggested that a patentable invention should give rise to a practical application in the improved use of computers. To add to the uncertainty, shortly after, the Federal Court gave judgment in the RPL case, finding the invention in that case, which related to a system for the assessment of competency or qualifications of individuals in relation to recognised standards, patentable. The court rejected the requirement that the computer-related features must be central to the invention, finding nothing in the case law supporting such a requirement. The research affiliate's case was appealed to the full Federal Court, and the decision of that court is now awaited. Meanwhile, in the US, the Supreme Court weighed in on the topic in June in a much-anticipated decision in the Alice Court case, finding that generic computer implementation of the abstract idea of mitigating settlement risk did not transform that abstract idea into a patentable invention. While the principles applied in the US are somewhat different, This decision confirmed a growing sense of antipathy to business method patents. Unfortunately, for now, there is a considerable amount of uncertainty around the criteria which will be applied to determine the patentability of a computer-implemented business method. However, what does seem clear is that the way in which a patent application is framed and the detail which is included in it could potentially have impact on its patentability. Those seeking protection for business method-related inventions need to carefully consider the parameters of their invention and the manner in which the computer software plays a part in its implementation. We can only hope that the full Federal Court will provide some much-needed certainty so that potential patentees can better assess the likelihood of obtaining protection at the outset. I'm Katrina Crooks from Shelston IP. Thanks for your time.